Federal High Court upheld the election of Aminu Tambuwal as Sokoto State Governor. Ex-Benue State Governor Gabriel Suswam pleaded not guilty to 32-count charges. Supreme Court sacks 2 legislators, orders them to refund salaries. Hello and welcome to Judiciary Watch. I am Augusta Yaku. We have a handful of judiciary news packages for you. Plus,
the office of the Attorney General should be a distinct office, and the occupier of such an office can either be a career civil servant.
Our Judiciary Watch discourse will be focusing on the advantages of separating the offices of the Attorney General and that of the Minister of Justice. Please don't go away.
Continue to watch the Judiciary Watch.
It brings information, awareness of legal rights closer to the people.
There's no program that is like it.
The Abuja Division of the Federal High Court has upheld the election of Aminu Tambuwal as the authentic governor of Sokoto State. The court, presided over by Justice Gabriel Kolawole, said the application challenging the accuracy of the December 4, 2014 primary election of the All Progressive Congress in Sokoto State, through which Tambuwal emerged flag bearer of the APC, lacked merit and is therefore dismissed.
The plaintiffs in the suit were 2 former aspirants for the governorship position of Sokoto State under the platform of the APC. They are Usman Dahiru, a former senator, and Abubakar Sayina, following allegations of non-compliance to lay down rules by the party to select its flag bearer. Justice Kolawole held that the plaintiffs were unable to prove the alleged irregularities, particularly the alleged non-accreditation of delegates who voted in the primary, which they claim marred the entire exercise. The judge added that even if they were able to prove their case, it will make no useful purpose to nullify the outcome of the primaries when the Federal High Court, not being an election petition tribunal, lacked the jurisdiction to order a fresh election in the state. For his part, Special Assistant to Governor Tambuwal on media, it is an expected judgment and not even a distraction to his boss. For the plaintiff, it is time to take a closer look at the judgment to know the next step. Having received clearance from a court of competent jurisdiction, Governor Tambuwal must fulfill the mandate given to him by the Sokoto State Electorate. Emmanuel Bagudu, PTV News.
Former Governor of Benue State, Gabriel Suswam, and 2 of his former aides have pleaded not guilty to the 32-count charges bordering on alleged money laundering brought against them before Justice Kolawole of the Federal High Court sitting in Abuja. Suswam, his ex-commissioner of finance, and the chief accountant of the Benue State Government House were said to have embezzled money belonging to the state government amounting to 7 billion naira. Trial Judge Gabriel Kolawole, who granted them bail of up to 250 million naira, ordered them to be remanded in Kuje prison until the bail conditions are met. The trial continues on 10th, 17th, 19th, and 20th October 2017. Justice John Toho of the Federal High Court Abuja has remanded the alleged kidnappers of Nigerian Turkish international school children in Kuje prison after the arraignment on charges bordering on kidnapping and terrorism. The 5 suspects appeared in court on Tuesday, but the arraignment could not hold due to absence of an interpreter. After pleading not guilty to the alleged offense, Justice Toho adjourned the trial to September 28, 2017, for the prosecution to call its witnesses.
In pidgin, and then it was also translated back to the court in English. So they said they understood. The court asked them, and they said they understood. They were asked, and they said they understood. Our witnesses are ready. That's why we're in court. If we do not have witnesses, we won't be in court to try them, because all our witnesses are ready, and are ready to testify, to show, to establish the offenses against them. And if the court finds them guilty based on the evidence we are going to lay before the court. It is their constitutional right to defend themselves in person or by a legal practitioner. So if they choose to defend themselves, fine. The Constitution provides for that. But if they choose to be defended by a legal practitioner, the provision, I'm sure even the legal aid is there to also assist them. I'm sure they will be represented before the next or by the next trial, by the next proceeding.
This is Judiciary Watch. More reports in just a moment. Welcome back. The Supreme Court on Friday sacked Senator Sani Abubakar Danladi, who is representing Taraba North Senatorial District, and Honorable Herman Hembe, representing Vandika Constitutional Federal Constituency of Benue State in the House of Representatives. The Apex Court held that the duo should within 90 days refund all salaries, allowances or emoluments they collected while occupying their respective seats. In a unanimous judgment, a 5-man panel of justices led by the Chief Justice of Nigeria, Walter Onogen, directed the Independent National Electoral Commission to issue certificate of return to Shaibu Issa Lau as the senator representing Taraba North and Mrs. Dorothy Mato as Hembe's replacement in Vandika Constitutional Federal Constituency of Benue State. In the Taraba case, Justice Ogi held that Senator Danladi was not validly nominated by the People's Democratic Party, PDP, to participate in the senatorial contest, noting that the appellant, Lau, was wrongfully substituted. Similarly, the Chief Justice of Nigeria, who led the verdict in the second case, held that Mrs. Mato was the winner of the primary election the All Progressive Congress, APC, conducted December 7 to 20th, 2014, with respect to Vandika Constitutional Federal Constituency of Benue State. The case between Luka Biniyat, a member of the Nigerian Union of Journalists, NUJ, Kaduna State Council, and the Kaduna State Government before the Kaduna High Court has been adjourned to July 12, 2017 for hearing on medical grounds. The presiding judge, Bashiru Sukola, granted the application for the adjournment of reviewing the medical report issued to the accused person, Luka Biniat, gave him 14 days to receive medical attention by the Sabo Tasha General Hospital, Kaduna.
Medically, physically, before his trial is commenced by a court. So from the medical evidence tendered by Mr. Biniat from the General Hospital Sabo Tasha, it's obvious that he has a medical challenge that will not allow him to be before the court unfettered, because that's the wording of the law. He must be before an accused person must be before the court unfettered. He must be before the court to be able to stand his trial. You don't try a sick accused person. That is against international best practice. So that is why the court, after reviewing the medical evidence presented by Mr. Biniat's lawyers, decided that they should adjourn the matter for the 14 days the doctor gave him to get better. It is the responsibility of any responsible state to maintain law and order. And any attempt to breach that law and order, it is the responsibility of the state to put a stop to it.
It's a fair proceedings, you know. It's fair because the court cannot put somebody on trial when he's physically unfit to stand trial. So what we did was to tell the court that the accused person, Luka Biniat, as the court could see physically, is physically not fit for that trial. And we had a medical report and the x-ray to show the court that he had been certified unfit.
It is now time for our Judiciary Watch Discuss.
ODIA of ODION solicitors, and on today's discourse we'll be looking at the Office of the Attorney General of the Federation and the Office of the Minister of Justice. Better together or not? You're welcome, sir.
Thank you.
It's an honor to have you on this episode of Judiciary Watch.
Thank you. You are welcome.
So on to our first question. We'd like to know what are the functions of the Office of the Attorney General of the Federation and the Office of the Minister of Justice?
Well, the Office of the Attorney General of the Federation and the Minister of Justice is a constitutional is constitutionally provided under our Constitution. If you go to section 150 of the Constitution of the Federal Republic of Nigeria, it provides for the Office of the Attorney General. In fact, that is the only office of the minister that is provided for in the Constitution of the Federal Republic of Nigeria. And section 174 of the Constitution brings out the powers of the minister. The Minister of Justice and the Attorney General, by and large, is the Chief Law Officer of the Federation. He coordinates all other facets of our justice system. As far as Nigeria is the #1 law officer of the country. And by the nature of our minister, he is also in charge of the Ministry of Justice. Then when you talk about the powers of the minister, apart from being the first law officer of the Federation, it also possesses such powers of nolle prosequi. That is to say, to enter nullification in any prosecution that is ongoing as far as criminal cases concerned in Nigeria. Then you also have the power to discontinue such cases. By and large, these are the powers of the Minister of Justice and the Attorney General. In Nigeria, the two offices are fused. The Office of the Attorney General and that of the Minister of Justice. Although, going by our Constitution, we only have the provision for the Attorney General of the Federation, and not with the nomenclature of Minister of Justice. But by precedent in Nigeria, the Attorney General has often performed the functions of the Minister of Justice as well. They are two big offices.
Okay, thank you, sir. So, from what you just said now, I would say one of them is the Chief Law Officer of the Federation. Maybe that's the Attorney General of the Federation.
Yes.
And the Minister of Justice could be said to be an administrative officer of the Ministry of Justice. Would that be correct?
That would be correct. But to expatiate on that, by being the Minister of Justice, he is automatically a member of the executive. and also by extension a politician. And that is why, yes, a politician. And being a politician and being a Minister of Justice, he must be appointed by the President. And if you are appointed by the President, it means you have to be loyal to your appointer, which is the President. But the Attorney General anywhere in the world is supposed to be for the people, always to be answerable to the people and to the law and to the Constitution. But if somebody appoints you, you owe that person a measure of loyalty, so also that you are at the mercy, at the beck and call of your appointer, that is Mr. President. So the position of being the defender of the masses, of the less privileged, of the poor people, by and large, is now being eroded by the fact that his loyalty goes to the executive, in quote, to the people that oppress the people. And you do not expect him to bring them to book in the event of infraction. And if you look at the precedents we have had in Nigeria, in high-profile cases, the Attorney General has actually done disservice to the people. If you look at Section 174C, it provides that even if you want to exercise your power of nolle prosequi, you should exercise such power for public interest. So if you now look at a case we call PEP, politically exposed persons case, and you now enter a nolle prosequi, would that be for the public interest? A recent example is the Chief Registrar of the Supreme Court, who was in court, taken to court by the EFCC, being prosecuted by a lawyer from the Attorney General's office. But the Attorney General entered a nolle prosequi. And when the public outcry came to the fore to say why, the Attorney General's excuse was that there were some Supreme Court judges that were undergoing trial that they wanted to now use the Chief Registrar as a witness, as a state witness. But the question is, the Chief Registrar was being accused for misappropriating or embezzling about 2 billion naira, while the Supreme Court judges is far less. So what is the correlation here? You cannot say. And they did not stop there. He was now elevated to be the present secretary of the NJC. But the point being made here, let us not deviate from the issue, is the fact that a nolle prosequi was entered by the office of the Attorney General. So, if you go by Section 174 of the Constitution, C, would you say that was for public interest? I leave the answer to the viewers.
Okay, thank you very much, sir.
My pleasure.
Well, what I would want to ask now is this: what are your recommendations? Because from what I understand, from what you have just said now, there is an interrelation between the powers of the Minister of Justice and that of the Attorney General. And it just happens to be that in the Nigerian justice system, they are seen as one, or it's one office. But don't you think their powers are, intertwining and correlated?
The powers are overwhelming. Yeah. The two offices, the powers they cover are intertwined as far as the present day office of the Attorney General and Minister of Justice is concerned. If I may take you back to the memory lane, we copied our justice system from the British angle that was practiced before the independence in 1960. Then thereafter, we adhered to it. That is where our president is coming from. But I will tell you, free of charge, that for the past 7 or 8 years ago, in England, they have separated the two offices, where we copied our jurisprudence in this regard from. Then why are we still holding tenaciously to the two offices being given to one person? If you look at the last Constitutional Conference in 2014, a recommendation was made to that effect that the two offices be separated. But if you also look at the last National Assembly, a recommendation was made. It was not just a recommendation, there was a bill before the last president, President Goodluck Jonathan. They call it the fourth alteration, that the two offices be separated. The reasons are that you cannot merge them together and expect service delivery in that regard. But unfortunately, the last president, Goodluck Jonathan, did not sign that bill into law before he left office. And that is why the two offices are still meshed together or fused together today. If you separate them, the advantages are numerous. If you separate them, the Attorney General would no longer be an appointee of Mr. President. It can, the occupier of the office as the Attorney General can even take Mr. President to court if they are violating the law. And you are aware that on daily basis, the executive violate the laws. If they are not violating the laws outrightly, they are observing court orders in the breach. Attorney General can take them to court. Or if the Ministry of Justice, they are prosecuting cases and they are not doing it in line with the laws of the land, the Attorney General can take them to court. That is how it's done in the advanced country. As we speak now, you are aware that in the United States of America, the Office of the Attorney General are one of the people that recommended those to investigate the President of America. The offices are distinct. The offices are separated. The advantages are numerous. And until that is done in Nigeria, the Attorney General will continue to be a politician because it's a member of the ESCO. Is an appointee of Mr. President. Is at the mercy of Mr. President. So it has its limitations if the offices are not separated. And that is why some of us, we have clamored over time and we have enjoyed the blessing of the last Constitutional Conference of 2014 and also that of the last National Assembly, that the two offices be separated so that the rule of law will be deeply entrenched as far as our nascent democracy is concerned. And justice delivery will come to the doorstep of the ordinary Nigerian. You are aware of the breaches of rights, human rights of citizens in the country today. And you are aware that the Attorney General that you come to their rescue oftentimes are the ones that will come to court to say why the law should not give redress to these people whose rights have been trampled upon. My recommendation in this direction would be that the two offices be separated. That is, the office of the Attorney General should be a distinct office. And the occupier of such an office can either be a career civil servant or maybe should become the Attorney General by election and not be at the mercy of the government of the day. And the process of removing such Attorney General in office should also be laid bare and be made rigid so that a president of the day cannot just wake up anytime and fire such an Attorney General. So the power to hire and fire should not reside in the president. So the office should be separated as it is right now so that the Minister for Justice cannot be the overseer, the landlord of the Ministry of Justice and galvanize their effort in that direction by sending their lawyers to the other ministries of government, by advising the minister, the government of the day. The two offices should be separated. And since the bill was already before the 7th National Assembly, there are processes in the National Assembly whereby you can revisit such a bill that was not passed by the previous administration. So they can revisit the bill. And I'm also happy that presently the National Assembly, they are trying to look at the 2014 confab recommendation. And if that is done, that bill, that recommendation will also become a bill. And I encourage that it should be passed into law.
Okay, thank you very much.
Always my pleasure.
It's really a thrilling time, and having this conversation with you.
Thank you.
You're welcome.
We have come to the end of today's episode of Judiciary Watch. We will appreciate all your comments and contributions on our email and social media platforms. Thanks, and remain law-abiding.